Hey guys, and welcome to today's video. Today we have a sovereign citizen that I've covered before. It was a said who decided to walk out his jury trial because the judge wouldn't play his stupid games. So, he won a stupid prize of having to serve 45 days in jail for contempt of court. Well, he's back, except he's no longer facing petty traffic charges, as he's upgraded to facing charges that can potentially land him in prison for the rest of his life. Here's a short news clip summing up his degeneracy.
A Grand Junction man was arrested in Florida by U.S. Marshals on an extradition warrant for Colorado. The U.S. Marshals Task Force and Walton County Sheriff's Office arrested Pablo Rocco Forenza this morning. The Grand Junction Police Department says the allegations stem from a possible intimate relationship with a victim that began when they were under the age of 15. Forenza is accused of sexual assault of a child, sexual exploitation of a child, and possession of exploitative material in Grand Junction. He's currently held in Walton County Jail, waiting extradition back to Colorado.
Now, we have several hearings to cover. Started with a short one that is a follow-up to his traffic charges that he walked out on. So let's begin.
What do you have?
23T 125.
23T 125?
Yes. Pablo Forenza.
This is People versus Pablo Forenza, 23T 125. Mr. Forenza does not appear. His appearance is hereby waived. Mr. McCall?
Based upon the other legal issues that Mr. Forenza is facing, the people are going to dismiss this case.
The court hereby grants the motion to dismiss. I vacate the pretrial readiness conference set for tomorrow afternoon, May 6th. I vacate the jury trial, which is set on May 14th and 15th. Thank you very much, Mr. McCall. Let's go off record.
So, they decided to drop his traffic charges that he was facing because the new charges make those seem extremely irrelevant. Now we're going to head to his arraignment, which takes place while he's in custody.
All right, looks like Mr. Forenza is present. Mr. Forenza, did you watch that video that talks about your rights?
Yes, sir.
And did you understand your rights on the video?
Yes, sir.
Can you waive for the reading and advisement, Ms. Atkinson?
Yes, Your Honor.
All right, so let's talk about bond and the protection order. And so, Mr. Savage.
Thank you, Your Honor. We did attempt to make contact with the named victim, and we have not, as of now, heard back from her. I just wanted to make sure she's not on. I don't think she is.
I don't see she's on WebEx right now.
Yeah, so, as the court probably knows, I think these are obviously, generally speaking, very difficult types cases to, I'm sure, for the court to set bond on and for the people to make bond recommendations on, especially having not heard from the victim. But obviously, Your Honor, the allegations are extremely concerning in this. They're, as the court knows, according to the victim here, they started a sexual relationship back when the victim was allegedly 13 and the defendant was 21 years older than her. I realized that this spanned over different states and over several years, and some of the things allegedly that happened in Colorado were when she was a bit older. But regardless, Your Honor, the allegations certainly are extremely concerning. And I think what makes it difficult, at least for the people, to make bond recommendations on these types of things is it's hard for the people to recommend or know what sort of non-monetary conditions could even be in place. I mean, at this point, I don't have even really a good address to know exactly where the victim is. I assume the number that telephone number we have from her is okay, but we have not heard back. So I'm concerned to just ask for like a GPS type situation. I certainly will tell the court I'm asking for no contact with the named victim in this case. And I'm also asking for a provision specifically that the defendant be prohibited from having contact with anyone under the age of 18 years old. I'm also asking for pretrial services. And I think, Your Honor, just based on the allegations, the serious nature of them, the fact that these are the types of charges where if he were to be found guilty, obviously would carry, indeterminate type sentencing options. I certainly think that increases risk potentially for failing to appear, those sorts of things. I know he does have a couple prior failures to appear in the last 5 years, 3 of them to be exact. I am asking the court at this point in time, Your Honor, to set a high cash only bond. I would ask the court to set something in the neighborhood of $100,000 cash at this point in time, as I do not believe at this point in time the court can set non-monetary conditions that would assure the safety of this victim at this point in time. Thank you.
All right. Thank you, Mr. Savage. The court should put on the record, just so both parties are aware, the court is somewhat aware of some of the factual circumstances in Mr. Forenza's pending other criminal matter here in Mesa County, including the fact that he fled his jury trial back in November of 2025. And so that is something that the court is aware of and thinking about in terms of what would be an appropriate bond in this particular case. So, Ms. Atkinson.
Your Honor, I believe Mr. Frenza had a question. May I please mute?
Yeah, absolutely. The court should also put on the record, I'm also aware he was extradited from Florida as well.
Okay. Yes, Judge. So we are requesting, I'm sorry, Judge. 1 second. So Judge, we are requesting that the court impose a $10,000 cash only bond or a $100,000 cash or surety. Mr. Forenza, I understand that the allegations in this case are extremely serious, but they are just allegations at this point. Mr. Forenza is presumed innocent of this. The court is required to presume that he's eligible for release with the least restrictive conditions. He's a CPAC Category 1 with extremely minimal criminal history. It sounds like the district attorney's office cannot even locate the alleged victim in the case. I think the court can consider how that might bode for trial at this point. My understanding was that he was apprehended in Florida because he was down there for work. He wasn't attempting to flee the jurisdiction at all. He lives in Mesa County currently. He works in IT. He's had that job his entire life, and he thinks he will still have that. When he gets out of custody, it's contract work, essentially. He would be willing to comply with some non-monetary conditions. I disagree with the district attorney's office that we can't assure community safety with non-monetary conditions. We could provide for no contact with children under the age of 18. He would request a exception for his biological daughter, Forenza. Does not live with him, but he would at least want electronic communication with her. He does need to be out working. There's a lot for him to situate. If he's going to be fighting this case, he needs to be working on getting his belongings situated. He needs to sell his vehicle. He's looking at hiring legal counsel. He would really like to be out of custody to assist with the investigation in this case, for which we are going to do a lot of. He has a lot of family in Grand Junction. His stepmother and his 2 brothers are here. He's lived in this area a long time. This is a very cold case, and the allegations are very, very old. He's been out in the community since then. There aren't really any other pending allegations. I understand that there is an allegation that he failed to appear for a traffic trial. My understanding is that Mr. Forenza was under the impression, I don't know at this point whether or not it was mistaken or what was happening, but he was under the impression that he didn't need to appear for that date.
Yeah, you're mistaken. But I don't blame her for not knowing the full details. But he was in the courthouse with the jury present, and because the judge wouldn't play his soft-tardying games, he decided he was just going to walk out of that jury trial, earning him a direct criminal contempt of court.
They are much less serious charges.
No.
It's a traffic case.
To be clear, he was there for his trial, okay. Said, I'm not doing this anymore, see you later, and left, getting past the deputies before they were able to apprehend him as he was leaving the courthouse. In the middle of the jury trial.
Thank you, Judge, for that clarification. But my understanding is that there was a belief that the trial didn't need to. There was a belief that he didn't need to be there, was my understanding.
Yeah, I would agree with that. The indication is that Mr. Forenza does not believe that the prosecution can prosecute him. He's asserting he's some sort of sovereign entity and can't be prosecuted.
My understanding of Mr. Frenza is asserting right now he's not a sovereign citizen. But there are non-monetary conditions, I believe, in this case that can allow him out in the community. The bond we are requesting is very high and would be further assurance that he would appear. I don't know what the bond situation was in the traffic case, but I doubt there was a monetary bond attached to it. I do believe with the addition of a monetary bond, we could ensure that Mr. Frenza appeared for court.
All right, thank you, Ms. Atkinson. The court has considered the arguments of both parties and would make the following observations and notations. First of all, I look at three factors: flight risk, danger to the community, danger to a specific person. In this particular case, the court has substantial flight risk concerns for Mr. Forenza. Obviously, Mr. Forenza, even in something as minor as a traffic charge, does not believe that he needs to show up to court, and quite frankly doesn't believe the court has any sort of jurisdiction over him or can make him do anything, to the degree that he simply walked out of his jury trial contrary to the orders of Judge Grattan. And so that inspires little or no confidence that Mr. Forenza is going to show up as directed. He was extradited here from Florida. Whether or not that's for work or for other purposes, it's another indication that Mr. Forenza has the means and ability to leave the jurisdiction. And in light of the fact that he's facing mandatory, possible lifetime prison sentences, in this particular case, there's a significant incentive on his part to flee. The court would note that the evidence in this particular case, the court isn't going to have the trial on the matter right now, but the court can consider the likely sentence pursuant to 16.4, 103, and 105. And there's substantial evidence, at least in the affidavit, that Mr. Forenza potentially committed these offenses. This would include his own statements in messages and emails that were sent to the victim in this particular case. And so while the court understands that the allegations are older, a lot of times in sexual assault on a child cases, the allegations are from older. There's nothing about this particular case that is stale by those standards. And so the court also has significant community safety concerns in light of the allegations. The allegations involve significant grooming behavior, a pattern of conduct. It's not some sort of isolated one-time incident, but something that went on for years. And again, involved some very concerning behavior, at least with what's alleged in this particular case. And so because the court feels that Mr. Forenza is a very substantial flight risk, and because the court feels that he is a danger to community safety, the court declines to do what the defense is requesting here in this particular case. The court thinks that a $250,000 cash-only bond is what is appropriate here in this particular case in light of those concerns. And so that is what I'm going to set.
$250,000 bond. Well, I'm just going to say it. $250,000 isn't high enough now. He won't be able to pay it, and he's going to be showing up to all his future hearings in jail's issued clothing.
I am going to make a requirement to that bond that Mr. Forenza report to pretrial services supervision. And another condition of the bond is that he not have contact with anyone under the age of 18. Now, Ms. Atkinson, I think you did mention that he has a biological daughter that's maybe under the age of 18. Is that correct?
That is my understanding, yes. Her name is Angelina Forenza.
Angelina Forenza?
Yes.
Okay, so the court will make an exception to that bond condition and allow him to have contact with Angelina Forenza. The court is going to issue a mandatory protection order that says that Mr. Forenza shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that he's charged with committing. Further, he shall vacate the home of the victim, stay away from the home of the victim, and stay away from any other location where the victim would likely be found. Specifically, he is prohibited from going to Drive, Grand Junction, Colorado, 81504. Further, he can't have any sort of contact with Brittany Williamson. That would include direct or indirect contact or communication with her. The court will note that this, first of all, I have to advise you on what would happen if you were to violate the protection order, Mr. Forenza. If you were to violate the protection order, you could be subject to punishment for contempt of court, you could be charged with a misdemeanor, or you could be charged with a felony for retaliating against or intimidating a victim or witness of the crime charged. This case is assigned to Judge Barrett's division. And so what we're going to do is come back for formal filing on April 22nd, which is a Wednesday at 8:15 a.m. Mr. Forenza, I can tell you that you're going to be allowed to readdress bond in front of Judge Barrett because he's your assigned judge on this particular case. Would you like us to appoint the Office of State Public Defender to represent you so they can be with you and assist at that next court date?
Yes. Yes, Your Honor.
We're going to appoint them right now, so they'll be with you and can help you at that next court date. But the next court date is April 22nd at 8:15 a.m. Thank you.
No. Thank you for setting his bond so high that he may never see the light of day again, even before his trial and future conviction have been completed. Now, we're going to head to his bond reduction hearing.
Ms. Atkinson?
Mr. Forenza?
Mr. Forenza, 26 CR 299. Mr. Forenza appears in person in custody with his lawyer, Ms. Atkinson. Good morning, ma'am.
Good morning.
Ms. Bauer, I believe. Yes, for the people. This is a formal filing.
We have received the complaint and information, and we would waive further reading and advisement. Mr. Forenza is entitled to a preliminary hearing. We are requesting a preliminary hearing, but we're not requesting to set it within the 35-day time frame. We would request to address bond, and we would request if the lawyers could approach for bond argument.
All right. Court has heard arguments from counsel up at the bench. I've considered the same as well as the file. The primary purpose of bond is to ensure that a defendant appears at each and every future court date. Other purposes of bond are to ensure compliance with conditions of bond as well as community safety and victim safety. When fixing bond, I consider a host of statutory factors, all of which the court has considered here, even though I may not mention them. I consider defendant's ties to the community, employment status, criminal history, history of failing to appear or appearing for court, and any empirically based scoring instrument that may assist the court in understanding a defendant's risk level should he or she be placed on bond. I consider the charges as well. Defendant is a CPAC Category 1, indicating he's at a higher likelihood to succeed on bond. The court doesn't put a lot of stock in that because of the following reasons. The charges here are exceptionally aggravated and involve the possibility of the defendant remaining in the custody of the Department of Corrections for the rest of his life. The underlying allegations, too, are very troubling and concerning if true. They span some period of time, involve alleged messages that are of great concern to the court. The defendant has a history of failing to appear as well 3 times in the last 5 years. Of most concern to the court is that he was at a jury trial not too long ago, refused to answer the call of the court, and then ran out of the courtroom and had to be arrested at a later date and time, indicating to the court that he is at a extremely high risk to flee. That was a case involving a low-level traffic offense. So if he's willing to engage in that behavior for a traffic offense, it's highly likely that he would do so for something as significant as the allegations here. He has also, as the court can see, looking through the files, evinced some indication in other civil cases of, I don't know how to describe it, but concern that he would not follow the orders of the court. I'm looking at a couple of protection order cases, 25C 656 and 655. He also has a historical history of not complying with court orders, according to the CPAT twice, I'm sorry, not twice, but once in New York, a criminal attempt, second disobey a court order conviction from 1999. Considering all of the foregoing and less of a concern are those civil matters that I referred to, but still within the court's registry that I wanted to take a look at, and something that I mentioned, but not dispositive by any means, the court concludes that the bond set at $250,000 cash only while high is the least restrictive I can impose in order to ensure the purposes of bond are met, particularly community safety, but most importantly, victim safety. The defendant is a flight risk. He was extradited from Florida. He did not flee to go there because of these charges, I note, but nevertheless, that's where he resided at the time he was arrested, given the representations of the prosecution as well about ongoing investigation or investigations. The court finds that this is the least restrictive bond it could impose in both type and amount in order to ensure the purposes of bond are met, it remains as set.
So in other words, no bond reduction for him, and get used to being told when and where you're allowed to eat, underscore, and sleep. Now, he hasn't said too much softish nonsense up to this point, probably because he was represented by counsel, but all of that is about to change. And in the next hearing, he's going to fire his attorneys that he hired because he thinks he can do a better job himself.
All right.
Your Honor, special appearance, not general.
I don't know what that means. Mr. Fitzgerald is here with his client, Mr. Forenza. Mr. Forenza appears in custody. Good morning, Mr. Fitzgerald, and for your patience.
Good morning, Your Honor.
Miss Bauer, I believe, is here for people. Mr. Forenza said something about special appearance, not a general appearance. I don't know what he was trying to say. Mr. Fitzgerald, what would you like to do today, sir? I know you're covering.
I object to this right now. Consent hearing.
All right, I need you to stop talking or you're going to be removed from the court. This is your one and only one. A lawyer, he does the talking for you. We're not doing this, Mr.
Terminating my lawyer.
Okay. We can talk about that another day. Mr. Fitzgerald sounds like he doesn't want to have counsel. So let me go ahead and let these folks. Mr. Fitzgerald, I know you're just covering from Ms. Geisinger, so may not be prepared for this. Maybe you are. I don't know. What would you like to do?
I'm not sure that I could be prepared for the statements that are being reported to the court. However, I can tell the court that we asked to bring up the question of my client's bond. He sent around $200,000 bond, and we had asked to have a reduction. Obviously, he doesn't want to see us forward, but I do believe that I have to advise the court as to our basis for the motion.
So I think I've addressed bond. I know I have. And in this courtroom, the way I've handled bond hearings is we do it once in person, and then if there's a motion in writing pursuant to SMAR 1610. 107. I can't remember. She one of the defenders always reminds me that requires a hearing within 14 days. Then I'll do that hearing in person with parties. But we don't perpetually address bond. It's just something that doesn't do, and the law doesn't require. So I'm happy to address bond subject to the rule that I just cited. If Ms. Geisinger files that motion. We can set it for a bond hearing subject to that motion being filed well. But we also have complication Mr. Forenza saying that he doesn't want counsel. So sounds like we should probably just set this for a hearing in the not too distant future. And in the interim, if such a written motion is filed at least 72 hours before that hearing date I set, then the expectation will be we address it at that hearing. It's filed the day before or the day of. That's not going to give enough time to get VRA compliant and muster a response. So don't expect to address it on the day of the hearing.
Understood.
Let's see. I am out the week of the 20th, but I can do this next week. And probably to give everyone enough time to do what I just said. Status of counsel hearings aren't usually super straightforward. If you file that motion later today or tomorrow, that would give the people enough time, and I'm saying 72 hours, not business hours. So if they file it tomorrow, that's more than enough time. Wednesday the 15th, 4 p.m.
It's clear on my calendar, Your Honor.
Okay. So Mr. Forenza, I assume someone from one of your attorneys will be in touch with you here in the not too distant future.
I haven't heard from my attorney at all.
Okay.
In fact, counsel.
Okay.
Also, I know no nature cause of crime, no cause held 97 days, nothing.
Okay.
Violation.
Sure. So Wednesday the 15th at 4 p.m. If you want to fire your attorneys, that's totally within your right. You hired them, and then you'd be automatically eligible for the offender, given that custody. Okay, well, that is proof that I think would be really important to show a number of different authorities. So next Wednesday, July 15th, at 4 p.m. If you want to fire your attorneys, get in touch with them. That's your right. If you don't want to have counsel, we can talk about it at that time too. If you want to retain alternate counsel, that's something we can talk about too. So Wednesday, July 15th, 4 p.m. Status of counsel, perhaps bond. We'll see everyone then. Bye-bye.
Thank you, Your Honor.
So powers of attorney.
Again, what that means.
It means that facing life in prison doesn't scare him, and he doesn't mind trying to defend himself instead of having a qualified professional do what they do best. Now, for his final hearing, the judge is going to go over the dangers of self-representation, ensuring that he won't have his conviction overturned for violations of his constitutional rights.
Okay, Mr. Forenza, what do you want to do for an attorney, sir?
No, I have a right to represent myself.
Okay, so I've got some questions for you. We've got to go through these questions before I can decide whether you can represent yourself. And when I'm done with that,
Jack, because you cannot make a determination on my behalf.
Okay, so Mr. Forenza.
I'm here by limited special appearance. I don't waive any rights. I challenge jurisdiction, all jurisdiction, and I want to establish on the record before we move forward any proceedings.
Okay, Mr. Forenza.
And I preserve the record for appellant.
Mr. Forenza, do you understand that you have a right to be represented by counsel throughout these proceedings?
I understand my rights, Your Honor.
Okay, do you understand that right, though?
I understand my rights, Your Honor.
Do you understand that right?
I understand I have a right to counsel.
Thank you. And I'm going to tell you, sir, that we can play this game. You're welcome.
Your Honor,
stop. Let me finish. You are welcome to do this. You can file papers about jurisdiction. You can file papers about anything you want. And I'm going to look at them. I'm going to give the DA a chance to respond, and I'm going to issue orders. That's how this is going to work. But today, right now, if I can't get through this, then I can't determine whether you can represent yourself. That's the law in the state of Colorado. Whether you agree with it or not, that's not my problem.
That's a violation of my rights.
Okay. I have a fundamental belief that I have to follow the law, and that's what I'm going to do. If you disagree,
laws or
that's
statutes,
great.
Your Honor. I'm challenging every jurisdiction. I'm challenging everything that you do.
Great.
That the DA does. I have not been, I have no nature and cause. I have no probable cause. I'm being unlawfully detained.
You're going to go back into the jail if you can't follow my directives. That's exactly what's going to, and we're going to keep doing this day in and day out.
Article 3,
until
Your Honor.
Article 3 what?
Subsection 1, you're supposed to be.
Of what?
Of the Constitution.
Which Constitution?
Not the state, the United States Constitution.
I'm an Article 3 judge?
No, you're not Article 3. Under Article 3.
Okay. Sir, do you understand you have the right to be represented by an attorney throughout these proceedings?
I do understand.
Okay. Do you understand that if you can't afford an attorney, and because of your status as an incarcerated individual, that you automatically qualify for the appointment of court-appointed counsel? Do you understand that?
I understand.
Okay. Do you understand that I would appoint an attorney to represent you if you wanted me to? Do you understand that?
I do understand, but I do not accept, and I will challenge that.
Okay, understood. I'm going to make sure that you understand the charges that you're facing, which are up on the screen here. Do you understand that you are charged with sexual assault on a child by one in a position of trust, 2 counts, both of which are class 4 felonies? Those particular charges, and Ms. Bauer, please correct me if I'm wrong on the possible penalties, carry with them the possibility of 2 to 6 years to life in the Department of Corrections, followed by an indeterminate period of parole. There's the possibility of those particular charges. I'm not sure if they're extraordinary risk crimes, but if they are, then Ms. Bauer?
Yes, it's 2 to 12 to life. They are extraordinary risk.
Okay, so then the possible penalties are 2 to 12 to life in the Department of Corrections. And what that means, Mr. Forenza, to break it down in somewhat more layman's terms, is if you were convicted either by plea or at trial, it would be a sentence, it could be a sentence of any number between 2 years and 12 years, and then it would be up to the remainder of your natural life. So it would be a sentence of 2 years to life, 5 years to life, 12 years to life, whatever the number at bottom is fixed, up to the remainder of the natural life, followed by the applicable period of parole. That's the range for those two offenses. Sexual exploitation of a child as a class 3 felony, that's also an extraordinary risk crime, I believe. That is 4 to 16 years in the Department of Corrections in the presumptive range, all the way up to 32 years in aggravated circumstances, as little as 2 years in mitigated circumstances. That would be followed by 3 years of parole. That is not an indeterminate sentence. So that is just a fixed number of years, and that's it. Sexual exploitation of a child is a class 6 felony, same thing. It's fixed sentence, it's a determinate sentence, 1 year to 18 months in the Department of Corrections in the presumptive range, all the way up to 3 years in extreme aggravated circumstances, as little as 6 months in extreme mitigated circumstances. If you were to go to prison, that would be followed by 1 year of parole. Sexual assault on a child by one in a position of trust is a part of a pattern of abuse, class 3 felony. Again, Ms. Bauer, please correct me if I'm wrong, but I think that one would be 10 years to 32 years to life? No?
That is the 8 to 24.
8 to 24 to life.
Yes.
So that's also an extraordinary risk crime. These particular statutes, crimes, sir, have unique penalties in the law. So I'm trying to make sure I get it right. That's 8 to 24 to life, followed again by that indeterminate period of parole. It would be 20 years to life of parole, to be exact. I need to go back to my sheet here. Give me just a moment. So do you understand the possible penalties?
I do understand possible penalties.
You're not waiving any rights by answering these questions. You're not waiving jurisdiction. You've already objected to that. That's all on the record. Everything's recorded.
I do challenge jurisdiction.
I understand. No, you already said that. You don't have to keep repeating it. Do you have any legal training, sir? Like, have you gone to law school? Did you go to college, get some legal training in college, taken some classes?
I'm a certified law professional.
A certified law professional. What does that mean?
It means that he attended Google University and spent a good portion of his life misunderstanding complicated legal topics, ensuring that he will be convicted of these crimes.
Under the Constitution and international level. I don't practice state law because the statutory codes Rodriguez versus Radon, all statutes are unconstitutional according to the Constitution.
Okay.
So I stay away from your statutory.
Okay. So you claim you have some legal training?
Yes, sir.
Okay. Did you go to law school?
No, I was going to apply, but I decided not to. I understand that the legalese that is used is basically doesn't make sense to our rights, and it's a whole different ballgame.
Okay.
I understand where it's derived from also too. I studied that.
Great. Did you go to college?
I have.
Where did you graduate from college?
I graduated from ITT Technical Institute.
Okay. And
Bachelor's degree.
in
Information security cyber specialist.
Okay. So you're a high school graduate from college, have some legal training. Are you not influencing alcohol, drugs, or medication that may negatively affect your ability to think clearly here today?
Well, obviously, I'm in torture cuffs and unlawfully detained, so no alcohol, no drugs.
Okay.
Torture cuffs. I wonder where we've heard that before. Oh, that's right. Chili_, Castro made that term famous. So, not only is he a kitty diddler, but he's also a proud member of the Jock Sock Brigade and their merry band of dickweeds.
Believe it or not, sometimes folks manage to get a hold of those things in jail, but
I don't drink, I don't do that stuff.
Great. Do you want to consult with the public defender, not as an appointment, but just to talk to them?
I would be waiving my rights and giving up jurisdiction.
It would not be waiving your rights. It would not be giving up jurisdiction. It would simply be consulting with the public defender before you make this decision.
No, sir.
Okay. Do you understand that criminal law is a remarkably complicated area, that folks like Ms. Bauer, I've been doing this longer than I have, They've gone to law school. They've practiced law for many years. They've had to take a test, pass a bar exam. It's complicated. It's not easy. Do you understand that?
I do understand that I'm being deprived free access to the courts and law to defend myself. And there's no resources for us here. And that's a violation. Okay, I do understand that.
Okay.
So had I have more stuff to do what I have to do and discovery and also Brady content, extrinsic, intrinsic evidence, everything, I would be able to fight my case.
Okay.
But I'm being dragged through this with nothing. So I've been unlawfully detained for 104 days now with nothing.
Okay.
You think that's fair? That's unfair trial.
Okay. So do you understand that criminal law is a complicated field?
I do understand it's complicated.
Okay. Do you understand that you have the right to remain silent and that anything you say can and may be used against you in future court proceedings?
You understand?
Do you understand that you have the right to confront, cross-examine witnesses, put on evidence in your own defense, demand a trial before a jury or a judge?
That's correct, and face to face.
Okay. And do you understand you have the right to subpoena witnesses to compel them to testify on your behalf or as part of your case?
That's correct, sir, but it's hard when I'm here and I have no resources to do that. So again, it's one-sided and the thumb is on the scale.
Okay. Do you understand that once you make this decision, there's a distinct possibility that there's no going back?
I do understand. I'm fighting for my right, my life and my rights.
Right. And you understand that by doing so, without counsel representing you, without the public defender, without privately retained counsel, that you take a great risk of not doing this right.
I take a great risk with counsel, and I do understand the risks involved. But
tell me what the risks involved are.
Not being provided the essential elements to the case.
Okay.
Can defend it. I 104 days, you know what I could have done with that? I've had my property stolen by these guys. I've had money stolen, my life stolen, and this goes farther back than this from Mesa County.
Yeah.
So there's a lot more involved in this than just this.
Right.
I've been stripped of my life, liberty, and property.
Totally justified. And I wonder if in your 100 plus days in jail, did you ever think about the innocence and humanity that you strip away from that 13-year-old child? I highly doubt it, since sovereign citizens have a tendency to only consider themselves when it comes to making decisions that might land them in jail for decades, if not more.
So going back to the consequences that you're looking at, you talked about the 104 days you spent in jail. I told you a few moments ago, if you were convicted at trial, the ultimate consequence here could be the rest of your life incarcerated.
That's correct.
And you want to run the risk of trying to represent yourself, thinking you're going to do it better than anyone else who could assist you, period.
Your Honor, this is the racketeering system here. I've talked and I've interviewed many people here, and it's the same thing with the public defenders. You put excessive bails. You just go to extreme, taking their life away. And I understand there's certain consequences. Yes, you have to do what you have to do. But I'm hearing the stories. I know I've learned a lot here.
Yeah.
I've learned a lot. A lot's going to be exposed.
Okay.
So what me going with an attorney is going to be no different than me doing it myself.
Okay.
I've had an attorney I paid for, and effective counsel, they don't even call me. I tell them I need this done, that done. They don't even do it.
Okay.
So how is that even worth wasting my time with?
So I don't know. I can't tell you the answer to that question. I mean, that was a privately retained attorney, whether it was privately retained or not. I don't know that I could answer the question.
With defenders, Your Honor, I get them and they go behind my back, and I find out I'm not going to go because I'm going to be filing on that, but stuff that happened.
Okay.
This is an injustice system.
Okay. All right.
There's no fairness here. I'm not going to have a fair trial. There's not going to be an impartial jury. I've been slandered all over the U.S., the internet. So how are you going to have a jury come in and sit now on my case? It's your duty to make sure that that doesn't happen.
Right.
It's beyond that.
Yeah.
It's beyond that.
It is my job to make sure you get a fair and impartial jury, and I will make sure that happens if and when we get to that point. It's also my job to try and advise you against making, I don't know that it's my job to advise you, but it is my job to tell you that you make a great chance of making a mistake by choosing to represent yourself. But I don't know that I'm going to be able to really impart that upon you any more than I have already done so. Especially when you have as much on the line as you do. You've convinced yourself that you can do it better. So,
Your Honor, if you don't mind.
Sure, I might mind. Depends.
The excessive bail.
Yeah, we're not talking about bail.
No, I understand.
And I didn't set your bail, by the way. I just upheld it when we had a bail hearing.
The prosecution fabricated, they didn't produce any evidence to me, submitted to me, and they used content that shouldn't even been in there, basically saying that I'm a threat to the public. Well, if this is back in 2010, 2011, I've been...
Remember, you have the right to remain silent.
Right, but there's nothing else. I've done nothing.
Well, I think at your bail hearing, I mentioned that there was a prior case in this courthouse, so somebody
was dismissed.
Right.
Right, and federal court had jurisdiction, Your Honor, and that's why Mr. Groton didn't want to accept that. So he unlawfully had me detained, okay, which is a violation. So it wasn't I didn't show up. I came there, I filed on the record with the court, and I also appeared and to verbally tell him.
And what happened when you did that?
He got mad.
Oh, he got mad. Okay.
He got very mad. So it wasn't like I was running, and it wasn't like I was trying to just not show up. No, I was performing to the contracts. And now they're dismissed.
Yeah, they were dismissed, but only because your new charges are so heinous that you're potentially facing life in prison when you're convicted. Not because you fulfilled your contractual obligations to courts. You dumb __.
So I'm not a threat. If I could be released to go do what I have to do, I mean, my finances, my credit shot, I mean, talking about unusual punishment, this is it. It's destroyed my life, my reputation. I would just like to get out there so I can get my stuff together and do what I have to do to come in here to fight this, because there's a lot more to this than what they know.
Okay.
And my evidence has been taken from me.
All right.
There's a lot more to this than, trust me, it goes farther than this.
All right. Well, like I said, if you think you're going to be able to do it better yourself from the position that you're situated in the Mesa County Detention Facility than an attorney representing you advocating on your behalf, then that's your choice. And I'm going to honor that request. So I'm going to find that the defendant has knowingly, intelligently, voluntarily waived his right to counsel. This is his decision alone. He has full awareness of the right that he's exercising. And he is competent and capable to at least the minimum degree to be able to litigate these matters himself. So with that being said, Mr. Forenza, this is otherwise a review hearing. So you're going to have to follow all the rules of court, all the rules of law. Like Ms. Bauer would, you're not going to get any breaks or benefits because of your status as a pro se defendant. What would you like to do today, sir?
Personam, pro se.
Yeah, okay. You can put all that in writing. What would you like to do today, sir?
Well, I'd like to express the excessive bail.
Okay, we're not going to address bail on the record because we've already done it in person. There's a specific statute that allows you to demand a hearing on the issue of bail one time in person. You can file that motion and I will look at it and then we can schedule it for a hearing. So what would you like to do next?
I would like to compel the prosecution to turn over all discovery.
Very well. So they have to give it to you by law. I imagine your counsel, former counsel, Ms. Geisinger has all of the discovery, but the prosecution has an obligation to now give it to you directly. It may be, I don't know what facilities the jail has for you to be able to watch it, look at it. Some of it, I think, I don't know. I don't know if any of it is of a nature, given the charges, that would require some further accommodations. But at least the bulk of it should be able to be transferred to the defendant. Ms. Bauer, how quickly can you get it to him?
Well, there is CSAM, so can't transmit that to him. And I know that a lot of the discovery, we had been asking the defense attorney for a flash drive because it was too much to be able to just send.
Okay, well, you're gonna have to get it to them. So whether you put it on a disk, flash drive of your own, they'll be getting you your discovery and they have to do it within a prescribed period of time.
Including the Brady content, Your Honor.
Well, of course, they have to. They have to give you exculpatory information that's in their possession. Otherwise, they risk losing their right to practice law. And by they, I mean Ms. Bauer and anyone else who may handle this case. What Ms. Bauer was saying, though, is that there could be what's called sexually exploitative material within the discovery that by law cannot be just handed out to defendants or even defense counsel. It has to be viewed in a secured environment. If you wish to have access to that particular type of information, evidence to the extent it exists, I don't know. I don't have discovery. That's not something I'm privy to. Write a letter to Ms. Bauer, and she's obligated to try and facilitate your ability to kind of observe, view that evidence in the secure fashion that all defendants' counsel has to view it in. But given your unique circumstances, because you're in jail, it may be a little bit more complicated than typical, but it'll have to get sorted out, and I'll expect it to. So your discovery is going to be coming. It'll be coming soon. I'm trusting that the jail has some way of inmates being able to look at discovery on a computer. So I'm seeing heads shaking, yes.
Also, Your Honor, jail is supposed to be providing any type of, you call it pro se packs. And
I don't know what that is.
it's paper, pens, resources to actually do what I have to do.
Okay, I get letters and motions from defendants all the time.
Okay, well, I mean, writing with a pencil and this little flexible pen and stuff is hard. So, I mean.
Boo, __, who? If you don't like writing with a pencil or flexible pen, then maybe don't do reprehensible things to children. Sorry, but I have no love for sovereign citizens. And if it wasn't for YouTube's guidelines, I'd tell you how I really feel. So, in the meantime, just use your most creative imaginations.
This is what you asked for, Mr. Forenza. I don't know what you want me to give you a computer. I can't give you a computer.
I'm requesting to be released so I can fight my case.
Yeah. I told you how to go about it.
Excessive bail, which should be at least to where my financial needs could meet it.
Okay.
It's just, that's where I'm at.
Right.
And the fact that, what they have stolen, which has nothing to do with the case, goes far and beyond this.
Okay. So I guess what I'm hearing is you want to get the discovery. You want to be able to go through it. You're contemplating perhaps filing a motion to modify your bond, and you need time to do all of this.
Yes, sir.
Okay. So we'll go ahead and set this over for how much time do you need to get him the discovery, all of it, Miss Bauer, Miss Marks, I guess? You're just going to have to put it on various discs. I don't know what the jail has, but.
Sounds like a couple of weeks, and I guess the question is, do we want to set it for prelim? Or
He didn't ask for that. If he does, I'm happy to set it for a prelim.
Yes, sir.
Do you know what a prelim is?
Yes.
Okay. So we'll go ahead and set it for a prelim. That's, you've already told me you know what it is, but I'm going to just tell you it's a hearing where I'm going to determine whether there's probable cause to believe that you've committed the offenses at issue. That would be all of them because they're felonies and you're in custody. Your previous attorney waived your right to have it within 35 days, so I don't have to set it within 35 days, but I imagine you probably don't want it set that quickly because you want to at least have a chance to look at the evidence before you can go
Yes,
forward.
please.
Okay. Yes, please, what?
I'm sorry. I would like to see what.
Yeah. So I'm going to give you a little bit of time, and then if technically you don't have a right to discovery before the hearing in the first place, but I'm going to do my best to accommodate this so you can have a chance to go through as much of it as humanly possible and present your case. About an hour is what I'll set aside. Anything else, Mr. Forenza?
No, Your Honor.
Okay. Mr. Forenza, I said you may not, there may very well be no going back in terms of your decision to represent yourself. I want to see you have the best chance here, sir. I don't have a dog in this fight, whether you believe that or not. I don't care.
I understand you're there to.
But my goal is to make this as fair as possible for all involved. You have a ton of rights. You have a basket of rights, and you can compromise your ability to exercise those rights if you don't know how to use them correctly. A lawyer could help you. That's all I'll say. So when I said, once you go down this road, you may not be able to go back, the further and further down this road we go, the less and less likely it becomes that I'll be entertaining a motion or a suggestion from you. Judge, I realize I've gotten in too deep. I don't want to spend the rest of my life in prison because I made some terrible choices about not getting a lawyer, this, that, or the other thing. Can you please appoint a lawyer? Please give me a second chance. Just know that.
Your Honor, my experiences with 5 lawyers have done absolutely nothing for me but drain my money.
Okay, well, I don't know if you've had public defenders before. They know what they're doing. They're excellent attorneys. That's all they do. I understand you may think there's a conspiracy between them and the prosecution and maybe the court. I don't know. I told you the other day, if you have such evidence, there are some folks who would be really interested in looking at it. If you're just saying that to say it, then there's no harm, zero harm.
This is why they went.
There's zero harm in having a public defender come and meet with you, talk to them. If you don't like them, you want to continue down this path, it's your right. I've already made the decision. You can represent yourself. But perhaps you meet with them and you decide, whoa, these people do actually know what they're doing. They're going to fight harder for me than anyone else. And I need to kind of reverse course. We can talk about that too. It's your choice. You've made your decision for now, and I've granted your request. Like I said, the further down the road we get, the less likely it becomes that I'm going to let you reverse course again. We're adjourned. Thank you.
All right. So that's the end of today's video. I really hope this guy gets burned for his actions, and I will most certainly be following up with his hearings as they progress. Now, I do want to let you know that I muted the victim's name and address in this video because that person has already had to deal with enough pain and anguish at the hands of this __, and I feel like it was just the right thing to do. So, if you want to see him burn in hell for his crimes, too, then hit the like button. If you don't, then hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss his next appearance.